says preparing to live stream the webinar.
It says now streaming live on YouTube.
Yeah, you see that? Webinar is now streaming live on YouTube. Can somebody just check that it is?
Yes, it is. I just got the notification.
Okay, so did I. Okay. So do you want me to announce that this next case is from this morning?
Yes, please.
Okay. So we're continuing the one morning case, a continued hearing case, item number 13332. This is a review session. I'm sorry, it's a public hearing.
Public hearing for this.
Sorry, public hearing, I apologize. 33279 BZ, 4320 Little Neck Parkway, Queens.
I believe Mr. Dale has been patiently.
I'm here. Good afternoon.
Good afternoon. Say your name, please.
Todd Dale, attorney for the applicant. Risa Chain, the property owner, is also here.
Okay. So they're the only two people because I have to swear. Are we ready to be sworn in?
We're the only two people, and we can be ready to be sworn in.
Okay. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
Yes.
Yes, affirm. Okay.
Go ahead.
So good afternoon. So from review session, we did hear the comments of the board. I just wanted to make a brief statement to follow up on some items, but then also to confirm that Risa Chain, the property owner, is here and available to answer any additional questions the board might have. You know, we understand the adjournments that have been granted on this, and we appreciate the board taking time to hear the circumstances and explanation of why we hope to have another adjournment. First, just to confirm, at the last hearing for this item, which was February 11th, Ms. Chain, the property owner, was at the board and did testify in person. Chair, you may not recall this because you actually weren't there for the early portion of that particular hearing. I just went back and listened to the February 11th tape. So you did not have an opportunity to speak to the property owner previously, but we were both there and we explained the circumstances surrounding the situation. Just briefly to confirm, you know, there were circumstances that unfortunately combined to cause delays in getting the necessary work done at the site. One was, you know, this was a family site, and Ms. Chain, who is now the current owner, it was a family site, and she just recently came into active management of it. But compounding that, there were issues that were financing that were detailed at the previous hearing, with difficulty getting in a medical tenant that was coming in, but also a previous restaurant tenant that had left. So there was cash flow issues. And then also during the course of reviewing the necessary repairs that were going to take place at the site, it was determined that a dry well needed to be removed and replaced. And that was a predicate action to everything else, because it didn't make sense to pave and stripe and do lot work if you were just going to need to tear up the lot for the dry well. So at the previous hearing, we explained the circumstances. The board understood that and granted a very generous, long adjournment until now, until August. However, as everyone knows, in March, the pandemic hit. And, you know, as Ms. Chain can speak to, she also was actually personally affected by the virus. And that just led to a series of circumstances where work just couldn't be done, even if they wanted to have it done. But it just all compounded upon all these factors adding up, trying to move forward. With our submission, we just tried to submit as much material as we have to show that, you know, the property owner does take this seriously. They do want to go ahead and repair anything at the lot that needs repairing, but also to upgrade its appearance. You know, just to confirm, this particular site is just a parking lot, and it is in the residential district, but it is, as I believe Vice Chair Chanda noted, a large site that's just used for parking that provides a buffer between the residential uses and the commercial uses that are fronting on Northern Boulevard. You know, there are other circumstances moving forward, but at this point, you know, we understand all the adjournments that have been granted. We appreciate the board's patience, but we would also say that the circumstances since this last hearing in February are about as unique as you can get in the current world environment. But now that, you know, construction and projects can move forward, there is a commitment to moving forward. And if the board will be willing to grant another adjournment, we would be appreciative. And if it would help, ease some of the board's concerns, we could make it a very short adjournment so the board could track and make sure that active progress is moving forward, and perhaps set forth a few of the smaller projects or a few of the initial site things that need to be done, just so the board can track progress as we move forward. So I just wanted to make that statement. And then, as I said, I'm here and the property owner is here and available to answer any particular questions.
I think some of this is a misnomer about the use of the word adjournment. I say adjournment, especially on these Zoom hearings, there's no testimony at all. We just don't hear the case, right? So if there was testimony, which is true, I wasn't present for the last hearing, it shouldn't have been called an adjournment because there was testimony. We actually had an open hearing, right? So this would not be considered an adjournment because you're testifying about the current status of things. That's information to us. Plus you submitted documents even if they weren't what we had asked for in the last. Understood. So the answer is no, it's not an adjournment. And by the way, it doesn't look good when you have so many adjournments in a row. It looks like you're not taking us seriously. So you should be careful and not allowing things to be characterized as an adjournment when you're present, especially when the owner is present. So can you give us some sense of the time, understanding COVID and financial situations that I'm sure are different than they were 6 months ago, et cetera?
I will defer to Ms. Chain to speak to the timing and the dry well and the plan for going forward.
Okay, hi everybody. First I want to just say that thanks to Vice Chair Chanda for visiting the site. I think she understands exactly what's going on without me saying a word. So I made some notes. I appeared before the board in February, and I essentially promised to have this lot substantially done by July. I got estimates, I got the funding in the form of a bank loan, and we were ready to go. And waiting for the winter to subside. It wasn't a bad winter, but you can never know. So as far as paving and that goes, we were waiting for the early spring. And then came the virus. I hired the borings company then to do the borings because I wanted to go forward anyway. And then I got the virus personally. So I couldn't follow up on any of the work because I was in bed at home. And then I had to quarantine after that. When I got back to the office and I called the boring company, they said the construction was shut down in New York City and they would get to it when construction could be done again. And I think it was around the second week of June where they said they could go back to work, but they had a backup of other obligations, and they finally got to it, and I bothered them and I got the reports. And I got it to my architect to do the drawings because they needed to, my GC needed to know what size dry well, because Todd's wrong, Mr. Dale's wrong. It wasn't a replacement, it's a brand new dry well. It's in addition to what's already there. So we needed to know the size, and I did get that plan just a couple of days ago. And so that is something I can move forward with. As for everything else, oh, I forgot to say that also in March, I got a letter from the bank withdrawing our funding. So we're back to having no money. The largest tenant that we have that has an obligation to pay 2/3 of the taxes on the lot, on the lot and the stores that are serviced by the accessory parking was also made to close in March. He's not opened yet. According to the rules of the city of New York, he cannot open until further notice. He cannot do sidewalk tables or a tent in the parking lot or anything like that, like other restaurants, because it's a shabu-shabu style hot pot restaurant where you sit at the table and each customer has their own pot to cook at, and the whole place is wired and vented for that, and that's not something that can be done outside, nor is it something that can be done using takeout. I prevailed upon him to try a takeout menu and see if he could cook the soup inside and get anybody to buy it. And he was open for a week in takeout, and he took in $100. So he closed again because that was not possible. Meanwhile, on July 1st, I paid $100,000 in taxes, every penny that we owed. I don't have any money left. The restaurant has not paid rent since April. He paid partial rent because he got a PPP loan of $80,000, 25% of which could go to rent, and he gave me $20,000. I haven't gotten a penny since, and I don't know when I'm going to get any more money. So I may have enough to do this dry well. It looks like it's going to cost about maybe $13,000. I don't know how I'm going to pay the taxes in December. And that's about all I have to say. I made every effort that I could, and I would appreciate understanding that I think Vice Chair Chanda knows that I need. It's a very big lot. It's a very big bill to do anything. It can't be done piecemeal. I'm still keeping it maintained. I did restripe it so that it looks a little bit better. I am taking care of repairs that need to be done as they need to be done. And that's about it.
Okay, thank you very much. Do appreciate that you called in, and sorry for especially the COVID-related hardships. Any other comments from commissioners? Okay. So what I'd like to suggest that we take a look again at the site after hopefully there's some improvement in the situation, maybe in the beginning of the year. That Ms. Chain continues to endeavor to be able, for instance, Small Business Administration is giving loans. I know of one that was issued just yesterday, so it might be worth looking into small interest or no interest loans, both federal and state, and even city.
I've tried to do that. I think I need some specialized help because when I went on the to fill out all of the applications, they want tax returns and records from last year to see how we did last year. Okay, last year is when that restaurant went in, and I paid over like $140,000 in a broker's commission. So it looks like we made no money. The whole there's no profit to say, well, we made profit then and now we're not making any profit because all of the expenses last year wiped out the profit. So I'm not a finance expert or anything, so I can't really figure out how to explain on an application why we made no money.
It's bookkeepers and accountants for making these filings, but I also so I would recommend.
I'll try. I will try.
And also reaching out directly to small business. In fact, we have a contact information which we could get to you for the small business helpline.
Sure. That would be great.
Yes, if any of that information is available, we'll definitely pass it on. And our office does work with other businesses, and we'll see if we can find something to help supplement what's going on also.
Okay, that would be great. Okay, does anybody have any of the commissioners have an objection to us just putting this on for, say, just to throw out a date like February for an update? No? Okay. All right, so we'll do something like that. We'll schedule it for a February continued. We won't call these things adjournments because we are trying to get progress. Okay, so please don't adjourn the next hearing. Attend.
We will not.
Okay. Okay.
I'll be there.
So noted.
Thank you very much.
Thank you very much.
Actually, have to ask if there's any testimony. So go ahead, Bert.
Okay, so this is calendar number 33279BZ. If you are a member of the public who would like to call in, please note that this is a continuation from this morning's hearing, except that we're using the 2 p.m. Zoom meeting ID, which is 941-1217-8179. And you can call the phone number 646-558-8656 if you would like to present. If you have already called in, please use Zoom's raise hand feature to let us know that you're interested in testifying, or I see that there's a phone number in attendance. Please press *9 if you would like to speak on 332-79BZ. Again, that's 332-79BZ and *9 if you would like to testify.
Thank you. Just a few seconds.
I
These-
do not see any raised hands, and has it been about 30 seconds?
Yeah. Okay, great. So I think we can then move on to the next. Now we're going into executive review session.
Okay, so this ends the public hearing for August 10, 2020, 10 a.m. session. So we're now commencing with the review session for August 10, 2020, 2 p.m. session. And the first item is 17910BZ, 249 Duffel Street, Brooklyn.
Okay. So we have proof of service of initial application to officials and proof of notice of this video conference hearing to officials, but not to tenants. And I apologize for confusing notice of hearing that was sent to the applicant, instructed to notify tenants and not to notify tenants. So I don't know which one was the desired result. Community board waives its recommendation, stating that there have been no complaints about the site. A change in hours is requested to allow 24/7 operations. And of course, this is a gym and they're not allowed to operate at all. I just want to say, I hope that someday it will be able to do that, and at 24/7, which is the standard for this particular gym. And I believe, that, many of these gyms have had to close permanently. So I wish this location well. We don't have fire department review on this yet, though.
Yes, we do.
We do?
Yes. I think that John sent it earlier. Sorry. It was a conditional. Yeah, let me just tell you what it says. The fire department has reviewed. The last action on this application was, it has a total occupant load of 350 as per public assembly. Application number 321478557. The last action on this application was approved June 13, 2017. No permit has been obtained from Department of Buildings for this application. The establishment has been inspected by the Bureau's licensed public place of assembly, LPPA unit, and 2 violation orders have been issued for failure to obtain a public assembly permit. These violation orders are outstanding. These premises has a fire suppression system, sprinkler, and a fire alarm system that has been tested, and fire department permits are current. Based on the foregoing, the department is issuing a conditional letter of no objection due to the open violation orders. The Bureau of Fire Prevention will continue to inspect these premises and enforce all applicable rules and regulations. Respectfully submitted, Deputy Chief Inspector John Daly.
Great.
And that is dated today.
Okay. Thank you. Any other comments from board members on this application? No? If you do, please speak up. No? Okay.
I wasn't sure whether there were any conditions on the previous grant.
I didn't see any. I looked, I didn't see conditions.
Okay.
Other than the usual, no change in the operator, that kind of thing. The hours of operation, which they're proposing to change here.
Yes. Yeah.
Okay, next item is continued hearing appeals 58134 Windman Place, Staten Island.
Okay, and this is again a review session, so testimony will be taken later at the hearing.
Right, so the Department of Transportation did submit a comment letter, which we forwarded to the applicant, and then the applicant submitted a response.
Oh,
Increasing, they had asked for an increase in the curb cut, I think, from 12. So the applicant has submitted to 20 feet.
sorry, when did they submit the response? I only saw the DOT letter this morning. When did
The
the applicant?
response came a couple of hours ago.
Oh,
And
okay.
so we sent it to DOT. I also called Kalila and Tika because the applicant asked, do you think maybe they could? But I left them messages and I sent them emails to see maybe they could take a look-see and like a little preliminary saying this looks better. But unfortunately, I haven't seen anything yet.
Okay, so
So
it's,
the applicant has proposed 20 feet, I believe. As enlarged, the proposed curb cuts have been enlarged to 20 feet in response to the comment that the proposed 12-foot curb cuts were insufficient for two-way traffic. And the applicant has also provided a requested turning path analysis. So those two items have been responded to. And also curb to curb width of Silverton is noted as 40.5 feet. So that's letter went to DOT this afternoon, and hopefully we should hear something.
okay, well, so without DOT, we're a little stuck, but I'll just read my comments. So we had a June 1st submission of revised plans, and on June 5th, and start over again. We had a June 5th submission on the revised plans subsequent to the last hearing, and a revised statement of facts on July 25th. So the submission was piecemeal, which I don't like very much because it's quite confusing. We were promised a revised as of right 3.0 set in the cover letter, but we never received that. The area ways on Church were reduced to three area ways at 5 foot wide each to allow for more planting. That's better. Silverton still has a good deal of its frontage given to area waves and paving. But in defense of that, not that I like them, I don't like area waves as a concept, as an urban concept, but at least the building sets back 10 feet from the property line instead of the 5 feet you have on Church. So you have 5 feet for planting in front of the area ways. And then of course there were all those comments from the DOT, which we need to hear from. And we don't have, unless we got it now, fire department sign off. The earlier submission was an objection. So I don't know if we have a final submission from fire department.
I did not see it. I don't know if Jella saw it. I didn't see it.
Okay. So Commissioner Shanda.
Thank you. I was satisfied with the revised plan that has been submitted, where the applicant has provided more area for planting along Church Lane, and also has provided parking and provides the parking not along the street frontage. Basically, these are parking inside the property, unlike some of the other development that are along Silverton and Church, where the parking is right on the sidewalk. So this is a better layout and better development than what one sees in the area. And with the improvements that we have requested and what DOT is recommending, I actually saw the revised plan for DOTs. As long as DOT is okay with it, I don't have any additional comments.
Okay, great, thank you. Commissioner Otley Brown.
Yes, hi, I'm looking at the revised plans and I also do not have any additional comments.
Okay. Commissioner Shaita.
Thank you, Chair. I believe the DOT requires also a revised site plan. I'm not sure if they submitted that.
Yes, they did.
They did.
Okay, good. and like, apart from that, the scheme 3 that they promised that they're gonna be submitting, which you Chair mentioned, I haven't seen it, so I'm waiting for that.
The whole point of the scheme 3 resubmission was to show what an as of right would be, because we
Yeah.
said do the same shape as of right, so why aren't you showing it that way?
Yeah.
And I see that now I'm opening up the submission. There's a 20-foot curb cut now shown on Silverton. I believe it goes, you drive underneath the building in order to be able to use it. Anyway, I'm not sure if it's responding to every single comment because it's the first time I'm looking at those drawings. But anyway, okay. And Commissioner Shibeta?
Found the applicant to be very responsive. I believe this is going to be an asset to the area. And the only thing that I found outstanding was the fire department, but I believe Chief Daly, Deputy Chief Daly will be able to help us out to tell us if there is a position on it. And I guess that DOT is outstanding. Is that something that might be able to get done today, or we won't be able to?
Yes.
And
No, so they need to review it and we haven't gotten a sign off for them. So, and they had a lot of comments. So, we have to wait until we hear from them. So, all right. That's it. Thank you.
Okay, the next item is 2018-170A, 5103 Van Dam Street, Queens.
Okay, this is a Department of Buildings appeal. Okay, just a second. I have a lot of notes on this, so. So the submissions were made for this hearing on, so everybody's up to date with the submission numbers. Submissions were made for this hearing on June 10th, July 1st, and July 17th, which includes Department of Building submission. Confusingly for me anyway, the appellant submission continues to argue that DOB's alleged procedural issues related to the deficiency notice, which this board stated at the last hearing, is not in its purview and is most likely an oath question. In the face of DOB's submission asserting that the surface area of the signs increased in violation of section 52-83, 42-55C of the zoning resolution, the applicant in that submission, the first submission, provided no further information to refute that. However, Department of Buildings still relies on Department of Transportation circa 1978 photos without providing any clear form of measurement to support its assertion that the surface area of both signs increased. I can count the structural members that you see in the picture in a variety of ways, and each time I count them, I come up with different answers because the angle of the photograph allows you to see the structure through to the structure behind, and I can't tell from those images which side of the sign it's on. So to count the structural supports isn't really fair because I can't count them unless I have a much better quality photograph. So the 1978 photo of the east-facing sign is very blurry, and it isn't at all clear that the structural members shown as unused in the 1978 photo of the west-facing sign weren't simply removed subsequently, which they could have done. There isn't anything for me to hold on to with respect to that. The property, and then I want to say the aerial photo that was provided also circa 1978, something like that. I went to that historical aerialphotos.com site where when you go on the site directly, you can see a clearer view of the image than you can in what's submitted to us. And for the life of me, I cannot even tell which thing I'm looking at is the sign. So there, I could see a pipe, and then I see these other lines. Is it a sign? Is it a structure? I don't know what it is, so I can't use that as something available to refute or confirm the existence of that sign in 1978. And so I don't know how the Department of Buildings can. Not the existence, the configuration of that sign in 78. And I want to say with respect to these signs, all of the signs, but in particular one like this where the documentation is so vague, property rights in these signs are very significant. These are very, very valuable structures, right? So I think we should be careful about potentially removing a valuable property right in our decision without a clear demonstration of an increase in the size of the sign. In other cases, it's super clear. You look at a DOT photo, and then you look at where there's no sign, for example, 0 sign in the critical year, and then you look at a contemporary picture and it's taken from exactly the same angle sign. So that doesn't require any calculations, but in this, you really do have to have calculations, and I don't so far see it. Commissioner Shanda?
So I went to look through the documents again, and in appellant's June 10th submission, it relied on the 1940 permit. And when you look at the 1940 permit, it does not include the plan, but the text in the permit says that I quote, the exact location of the structure on premise or building diagonal on Van Dam Street front. Now this site, end of quote. This site, this building has frontage on Van Dam Street, which is the west facing side, which is the west side, and on 34th Street, which is the east facing side. So based on that statement from the 1940 permit, it makes it clear to me that the sign structure was initially for a west facing sign. At some point, east facing sign was added. So moving on to the oath part of it, it to me is a little disturbing that the appellant still refers to that. And if it's in its statement, it had stated that it would be able to correct the deficiencies. It's been since 2017, and the appellant has really not provided anything to correct that deficiency, either to us or to DOB. So it shouldn't take that long. Even if this were to coming to the board was an eventual process after resolving the oath issue, they should have been getting this information. The west facing sign, I go by this site quite often, so I was able to clearly count the grid, especially the west facing grid. The east facing grid, I'll get to that later on. The west facing grid has exactly 8 grid structure, 8 by 2, 8 horizontally, 2 vertically, with 2 legs to stand on. And when you compare the photos from the New York State DOT 1978 to the current, you can see that the sign that was there in 1978, it did not cover the full length of the 8 by 2 structural grid. It was 1 grid shy of the total structure. Because the 1978, at least you can see the grid structure very clearly because there wasn't anything in the back. You can clearly, the angle makes it very easy for you to see that there were 8 grids. So I'll accept that there were 8, the grid for the structure for the west facing was the same with in terms of the length of it, size of it. However, the sign size was smaller. In 1978, it was not as wide as the grid was built to, which the current signs are. All throughout that I'm familiar with this site. Whenever I go by the site, all the signs pretty much have been the same length as the length of the grid, which is maximizing that 8 grid horizontally. Moving on to the east side structure. The photo, while I agree the 1978 photo is slightly blurry, but if we often architects, what we do is we try to use some something that you can use as a measuring stick and try to kind of measure what is it in comparison to that. So I use the bulkhead that is facing Borden Avenue and 34th. And that bulkhead has not changed since 78 to present. And I basically used that bulkhead to determine what was the east-facing sign in 78 compared to what it is today. It has significantly grown compared to that, if I use the bulkhead as a measuring stick. And similarly, so has the structure. In the 78, it did not have that many legs extending beyond the bulkhead. There were no legs, vertical legs one could see that extended beyond the bulkhead that was visible. In the 2018 photo, it is clearly visible. There were 2 additional legs that were going vertically to tethered to the roof. So definitely the east-facing sign has been altered, was not legal before, and that should not have been permitted. I think on the west one, if the structure has not been altered and it is at its current location, which I think from the diagram photos it is, it should not be, then the sign size should not be any larger than what was in 1978. That's how I view it.
Okay. Okay, thank you. Commissioner Otley Brown.
I believe the appellant conceded in the latest papers that the east side sign did get larger, which we almost exactly knew that would have happened because I believe it doubled in width. And as to the west facing sign, I mean, I'm not entirely sure that it did get larger, but something would have happened to the structure though, even if it didn't get larger. So the question is, the fact that it was, the structure definitely would have changed if it didn't get larger, because now all of the structure is behind that west facing sign. Does that invalidate the legality? Because it was clearly would have had to have been dismantled to fix the structure and then put back on. So it's not supposed to be, according to what, 42-55A, should not be removed and then replaced. So
it was removed and replaced, or just removed?
No, I think it was, it's really hard to tell for sure what happened with the west facing sign. It could have gotten larger, which is why now the entire structure is behind the sign. Or it could be that the sign structure was changed, but the sign remained. But in order for the sign structure to change so that now it's totally behind the sign would have had to have been removed and then put back on. And doesn't that invalidate the legal non-conforming status of the sign? Because it was removed and put back on. So the question to me is does it make a difference either way you slice it, whether either the sign was actually enlarged during that period of time or whether the structure was removed and replaced and then the same size sign put back on? Don't both of those issues invalidate the legality of the sign? That's the question.
Interesting. Okay, thank you. Commissioner Sheta.
Thank you, Chair. First of all, I would like to express my frustration regarding the continuous repetition of the applicant accusing DOB of being wrong on procedurally. I don't believe this is the case. That DOB looked after they issued the notice of deficiency and the applicant responded back by submitting material. I'm not sure what else should have the DOB done before they issue the rejection notice. In other case, the same exact applicant is writing this in his submission. Pursuant to the local law and Rule 49, DOB conducts a review of claims of legal status and either an approval or a deficiency notice requesting additional information to support such claim of legal status. If DOB is not ultimately satisfied with the proof submitted, DOB issues a rejection notice. This is exactly what DOB has done. So this is regarding the procedural error. I don't think it exists. I believe what the applicant is counting on now is the DOB should have like gone back to them saying, oh, we don't buy that, submit something else. If you ask an applicant to submit evidence that satisfies your requirement and they fail to do that, that's it, it's done deal. The second thing, I got the impression from the latest submission of the applicant, and for me, it's not just an impression, but this is what the last submission, the latest submission implied to me. Originally, we got a permit back in 1940 for 80 by 31 sign or signage, I would say. So the total footprint is about 2,500. If you look at the two signs now, they are much less. So we're good. It doesn't work like that. If you haven't built the 80 by 31, whether it's two or one sign back in 1940, and you waited until further timing and you built two signs, you should play with the rules. And the rules say you shouldn't alter or increase the service area of the two signs after a specific date. Now, looking at the evidence submitted by the DOB, the two pictures or the four pictures, picture set that's comparing 1978 to 2018 for both signs, east and west. Does it appear that both of the signs were enlarged? Yes, it's not just by counting the structure. It's not just by looking at the angles where the pictures were taken, but if you geometry wise, if you have a shape, rectangular shape, it does have something called rectangularity ratio. And this ratio doesn't change if you scale up or down the picture for that. And if you look at the picture from 1978 submitted by the DOB, yes, it's blurry. Yes, you cannot probably count the structural member or know the extent of the frame. Now, if you look at the rectangularity ratio of that red picture to the left in the DOB submission, it has a certain length to width ratio. If you go to the other one, the one adjacent to that to the right, the sign that says flavor for the soda cans, definitely by at glance, when you look at this, the rectangularity ratio is much bigger. That means for me one thing, this sign has been played with, whether it's increased or something was added to the right or to the left. But based on my visual inspection to these two pictures, I believe the east sign was enlarged. Same thing for the west one. If you look at the photo to the left, it has a certain length to width. And if you look at the one to the right, it's like stretched. In addition, if you look at the supporting structure in the one to the left, you have like a one span that's not supporting anything. In 1978, if you move to the right, it's being filled. So for me, I'm like fully convinced by the DOB argument that these signs were increased or altered.
Okay, thank you. Is that it?
Yes, thank you.
Thank you. And Commissioner Shibata?
Thank you, Chair. I'm not going to speak any further on the procedural issue, but with regard to the east-facing sign, I do agree that I believe that it was not refuted by the appellant that this sign has changed. I'd like to hear him speak on that again, because this is a very, this is a property right, and I want to be sure of his position on that. With regard to the west-facing sign, I'm not convinced that the sign has increased, and I can't assume that the change in the structure frame is not simply, because it does seem like the frame is different or changed in some way, but I can't assume that that wasn't a permissible maintenance or repair of the structure rather than a tear down or substantial change. So with regard to the west-facing sign, I'm not convinced that that sign has changed. And I want to thank Commissioner Shadow for the regularity ratio, but I wasn't able to make such a determination as he did. I felt that the slight change of angle and the distance would make that an equation that I didn't have the information or the mathematical expertise to make.
Thank you.
So if the DOB is convinced that this is a different if this is a different size, they really need to provide something that is convincing enough to challenge someone's property right.
Okay, thank you. I would ask also, because we know there's so many sources of imagery, that the appellant, we often have this issue with this particular council representing the sign industry, where they don't kind of dig deeply enough. And even though we ask for things, they often don't give. We know there's so many sources. DOB's recently been relying on these DOT sources, but we know there are movie sources. There are all kinds of things like that, commercials, where you might see the sign in a better light than just simply the tax photo and the DOT photo. That's kind of like all we've got, right? And then just going to visit. So it seems to me if the appellant were really serious about the preservation of this sign, they'd go the extra mile and, so to speak, and research more sources, photography sources. So I would ask them to do that. Okay, thank you, everyone.
Okay, you finished?
Yeah.
Okay, so this concludes the public review session for 2 p.m. We'll now commence with the public hearing for August 10, 2020, 2 p.m. So new case, item number 14, 179-10BZ, 249 Deffel Street, Brooklyn.
This is Ackerman.
Please
Yeah,
state your
Frank
name.
sent you, sorry.
Okay, go ahead.
Mr. St. Jacques, please state your name.
I don't hear him. You're muted, speak up.
He's muted.
I don't even find him anymore. Where is he? Oh, there he is.
Right next to Kurt.
Up or unmute yourself. It's not showing you as muted. Maybe turn on your speaker. Speak now. Nope. Okay. 1 minute, he says. Don't forget to turn up the volume on your speaker.
Hi, everyone. Can you hear me now?
Yes.
Yes.
All right, sorry about that. I apparently was having issues with my headset.
Okay, let me swear you in. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
I do.
State your
Please
name,
proceed.
please.
I'm sorry, Frank St. Jacques for Ackerman LLP for the applicant.
Okay, go ahead.
Good afternoon, Madam Chair, Commissioners. I listened to the review session and just will make a few comments, and I'm happy to answer any questions. I'll note that the PCE is the only tenant of the building. So we did provide notice by the mailing to the affected owners, but there's no other tenants within the building to notify. As you noted, the PCE is closed due to the, I guess, the executive order. We did receive the FDNY's letter this morning, and I spoke to the applicant and the architect. there is a public assembly application that's in preparation. I reviewed it with the architect and just wanted to note to the board that we will need to update the floor plans in the BSA set. This will not come with any change to the floor area or the specifics that were previously approved and were seeking to be approved with this extension of term and amendment with respect to the hours. It's just simply there's going to be a change to the equipment layout, the exercise machines on all the floors to provide a better egress path and resulting in a better, I guess, a stronger application for the public assembly permit to the Department of Buildings. My understanding is that this was based on comments from DOB examiners on those floor plans that had been previously submitted to the BSA, or the same layout of the equipment. So I just wanted to note that change. Again, we'll explain that in a cover letter, and we'll show a comparison of what we had previously submitted earlier this year and what we would be submitting to the board now.
Okay, so of course, your plans are always bubbled,
Yeah,
right? And then a clean set signed and sealed with
Yes.
a cover letter, right? And so could you also submit then a copy of the PAA permit application, ideally already filed?
Sure. I'd be happy to do that. And yeah, I'm not sure what the status will be when we submit. I assume that should be filed by then, but I'm happy to include that with our submission.
Okay, thank you.
So the change to plans is not considered an amendment, it's a minor correction?
That's my understanding. There will be no change to the requested floor area for the PCE, nor will it result in any changes to operations, or so really it's a change to where the various exercise machines are located, so that we can have definitely a compliant egress path, but just a better egress path. I think it eliminates some of the distance from the previous configuration.
Okay, great. Any questions from commissioners? Okay. So then I would like to ask for participation from the public. Go ahead, Kurt.
The calendar number is 17910BZ, which relates to 249 Duffield Street, Brooklyn, which is an extension of term for a gym. And the phone number to call in is 646-558-8656. And the meeting ID is 941-1217-8179. And if you call in by telephone, please raise your hand by pressing *9. Again, if you call in by telephone, please raise your hand by pressing *9. We have 3 attendees and none of them are here to speak on this application.
Their names. The timer is on for 30 seconds, so I just want to give it 30 seconds. Okay, so Mr. St. Jacques, how much time do you need to make the submission?
I actually already have the revised BSA set in hand, so we could turn that around very quickly. So I guess as soon as you'll have us, we can get that submission in very quickly.
And how about the status of the PAA application?
I need to look that up. I know that what I looked at today was a complete application. I just am not sure enough about where it is in the DOB process. I know that they had received comments, but before I say something that's not correct, I can confirm that and maybe be in touch with the examiner with respect to the status on that.
Okay, all right, so.
Please make sure the plans are in accordance with the board's rules.
Yes, will do.
So, sorry. So this is a question. The plans are being updated only to change equipment layout. That doesn't really go to our findings as long as we have.
Okay.
So, and the PAA permit application is to fulfill the fire department's request. So my question is, does anybody have an objection to us closing this? in anticipation of receiving those things. All okay with that? Okay, council, any issues with that? Okay, council, thumbs up from council. Okay, so then I would like to make a motion to close, and we'll just give you enough time to maybe give us a more updated PAA permit. But anyway, our calendar for next hearing is too full, so we can't put it on for decision at the next one anyway, okay? So it might be the one after.
That sounds great. Much appreciated. And yeah, thank you. I think it's very clear what we need to do.
Okay, great, thank you. So for a motion to close,
Chair Perlmutter,
aye?
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta.
Aye.
Thank you. Thanks very much, Mr. Sancho.
Great, thank you.
Next item is appeals continued hearing 5813A4 Wyman Place, Staten Island.
And in the meantime, while we're arranging that, we just got a submission from fire department, which I'll read in a second.
We also did get, the applicant did submit the as of right. He said it was submitted on July 22nd. I didn't get a chance to go back and look. He said
Okay.
the as of right scheme was submitted on July 22nd, so he resubmitted it.
Folder, so,
Oh, I don't believe it was uploaded.
yeah.
Sorry.
Yeah, I didn't see it.
So this is, and it didn't make it to, so this was Tony's case. Do you know whether you got that email? Copy of the email? If you could just check that. I'm trying to just figure out like, where's the gap between it being sent to submit with a CC to the project manager and it doesn't get uploaded, because the goal is that the project managers need to see that everything they received in the folder. So, yeah.
I don't see that one. Let's see, I don't see it yet.
But actually, yeah. All right, so if we could just check on that, because these are procedural things I want to try to avoid the applicant suffering from us not being able to review something that actually was submitted. So, okay, so Mr. Goldstein, you want to state your name and
Jay Goldstein for the applicant. Do I get sworn in? I do, right? For an appeals?
this is an A case, so not yet.
Right. Okay, Jay Goldstein for the applicant. I think my video's working. I think my microphone's working. Tell me if I cut out in any way.
Okay, I want to let you know, at a fire department.
Right, I was copied on the email. The two conditions of the fire department L&O are actually noted on our plans. So they were already there. They're the same comments or the same conditions from the prior approval. So we kept them in place. They're on B2 of our proposed condition plans.
Okay, so just for the benefit of the board members who may not have seen, because it just came in, the building must be fully sprinklered, and the entire building shell shall be provided with interconnected smoke alarms, which shall be designed and installed in accordance with the building code. So those are conditions that we need to include in our grant. Okay.
That's fine.
Okay, go ahead.
So I'm sorry?
Tony?
No, I'm sorry. I didn't mean to interrupt, Madam Chair. I do see that an email was submitted on 7 o'clock at night on Wednesday, July 22nd.
Yep.
For the submission of the as of right.
Okay, so this is a request again to project managers generally, emergencies in life not, understood. But that please, when you receive an application, a submission by email, you must check that the submission was uploaded in its entirety, because then we don't see it, the commissioners.
Understood.
And then, not just Tony in general, right? And then the commissioners don't see it, and then we complain that the applicant didn't listen to us when in fact it did. Okay. All right, go ahead. I'm sorry.
So I apologize. I heard the comments from the review session, and I apologize for the piecemeal submissions, Madam Chair. The reason it was done was to give DOT, as stated in my cover letter, sufficient time to review our plans, make any comments, because I noted at the last hearing, Madam Chair, you mentioned that DOT was extremely backed up and we were trying just to be as proactive as possible to keep things moving. That's why my OCD doesn't allow for piecemeal. I would much rather get it in one shot, but I wanted to do this to keep it moving, to try and get this to the next stage of this process. So as noted by Ms. Matias, and I do want to thank Ms. Matias and Ms. Prenga for their help, me annoying them annoying DOT to try and resolve it. We got the responses from DOT this morning, and we responded by the afternoon. With the exception of one comment, all of the comments were with regard to the curb cut and Silverton Terrace. The only comment that came anywhere close to Wyman was they wanted us to include a ADA ramp at the corner of Wyman and Silverton. We submitted a cover letter detailing all the changes. We submitted the changed plans, and we submitted a bubbled copy of all the plan changes in accordance with the board, and in hopes that that DOT could possibly take a quick look as I continue to talk, and maybe we'll get lucky and get an email from them. So DOT has our comments. Again, none of them were with regard to Wyman itself or with regard to Church Lane, but for asking us to increase the size of the curb cuts and show the dimensions of Silverton Terrace, which we did. FDNY conditions are already noted on our plans. So the only outstanding question was with regard to scheme 3. So at the prior hearing, the board asked us to bring scheme 3 back to the rear yard equivalent line. And in doing that, we were able to recoup some square footage, which allowed us to include a couple of additional apartments, which necessitated the 2-level parking as with the current plan. However, under scheme 3, the as-of-right scheme 3, as you can see on the plans, if you have a chance to look at them, we still do have a loss of 15% of the allowable floor area based on the street widening line. That's in addition to the almost 4,400 square feet that we lose as a result of the M3 district. So there still is a significant loss associated with as-of-right scheme 3, even when we do maximize it to the rear yard equivalent line.
Okay, I see 4,900 square feet.
That 4,900 square feet is the 15% within the residential district. That's in addition, this property, if you look at the top of that sheet, has an M3 district. We didn't include any of those calculations as discussed at the prior hearing.
Right.
So
Okay.
that's in addition to the 4,900 square feet of floor area that we lose in the M zone. So it's 15% plus whatever's in the M zone.
Well, the M zone, we can't give you residential anyway under this.
That's why we didn't include it in our calculations.
So we're not, so that's outside of the realm of the question. So it's the 40.
Yep, that's why it's not included.
Okay, don't throw it in there then.
We did not. We took out all reference to the M zone. But again, it is a 15% loss on an as-of-right project. And as noted by the members of the board, the proposed plans did incorporate a lot of the board's comments and does provide a much nicer building and a much nicer street condition than you have on the as-of-right projects along these streets.
Okay.
So we hope that we've responded to the board's comments.
Okay, any comments from board members on this? Further comments? So what we could do is we could say, because we don't know whether DOT is okay, right? But what we could do is say, we could close this, and then if we get a sign off from DOT, we can vote on it. If we don't, we reopen because further submissions will be needed. Is that okay?
Okay. That would be perfect. I asked that, so I'm confident we're going to get DOT green light at some point. But if they do have comments and we do respond during the period between hearings, and then they give the sign off, is the record still open so that we could still have our decision at the next hearing?
It sort of depends. If like, I'd say, yeah, I sort of say it depends. The record's always open for submissions.
Right.
It depends on whether the change that you make, because DOT may say, do the
building.
Say, oh, we hate this. It really messes up the whatever, something.
Right. So assuming it does not impact impact or change the building in any way, then I can submit, I can still get my green light. We can still get our decision at the next hearing.
Yeah, I think that's fair. council? I just want to make sure.
Yes, I agree.
Okay,
Okay.
that's fair and much appreciated.
Okay, there we go. So there isn't actually a submission to us. It's just,
There's no submission to DOT either.
yeah,
We're
so
waiting for, we're just waiting for DOT response.
just waiting for DOT. But in the meantime, lest we be accused of jumping the gun, we should be hearing from the community if they're interested in this application, which is 58-13-A for Wyman Place in Staten Island. If you're interested in giving testimony on this, please dial the number on the screen, 646-558-8656. Meeting ID number 941-1217-8179. And when do you hit the *9 right away?
After you log in to the Zoom meeting by telephone, if you're using the telephone, please press *9. I see that there's one phone attendee in the waiting or watching the webinar. So again, if you would like to testify on 58-13A, please press *9 now.
Okay. I
That's
will.
my architect.
That's your architect?
991 is my architect.
Yeah, okay, so. Okay, but I'm gonna time this so we have the 30 seconds. I should say. This is just to allow for the time delay on Zoom.
It does not appear that anybody has called in.
Okay then, so I would like to make a motion then to close.
Chair Perlmutter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta.
Aye.
Okay. Oh, and Mr. Bell has his hand up. Go ahead. And Roy? Asking you to unmute. Roy, did you want to say something? Maybe it was a mistake.
No, it's a mistake.
Okay.
Sorry.
Okay.
All right.
Go ahead. All right. On to
All
the
right.
next.
Thank you all very much, and thank you again to the members of the staff for their for putting up with me and for their tireless efforts in pestering DOT.
They are
Have a good
tired.
day, everybody.
Thanks for calling in and participating in our new and improved version of Zoom.
It was good. It worked out so far. Thank you. Have a good day, everybody. Bye.
Okay, next item is 2018-170A, 5103 Van Dam Street, Queens. Should be applicant and DOB.
Mhm. We have DOB and we have the applicant, so appellant. So we can begin. Go ahead when you can hear us, Mr. Kildoff. Say your name.
Yes, thank you. Good afternoon, Madam Chair, Commissioners. Patrick Kilduff, Charter Krinsky and Grogan for the applicant. First of all, I hope everyone managed well with our recent storm after 5 days out of power, just making working from home even more fun. So I'm glad. Hopefully, we're getting a little bit back to normal. I did listen to our to the board's executive review session earlier today, and I took to heart the board's comments with regard to the procedural issues. I'm not going to go through that ground again. I take the board's position that that's not within their purview, whether or not there was some irregularities in the procedural posture that brought us to this point. With regard to the substance, as the chair correctly pointed out, this really comes down to a question of the two sides of this sign structure, the east-facing sign and the west-facing sign structure, and to see what exactly was done with respect to each of them. As we had noted in our last submission, yes, it does appear from photographic evidence and the documentation submitted by DOB that there may have been an increase in the surface area of the east-facing sign. Again, we would note we're appearing on behalf of the applicant, Clear Channel Outdoor, which is the outdoor advertising company operator of the sign for the last few years. So we don't have any other information with respect to the east-facing sign and when it was or to what extent the surface area of that sign face was increased. We are, however, staying consistent with our position with regard to the west-facing sign, the larger of the two faces, which we have as an industry standard size of 20 by 60 or 1,200 square feet. We have not determined any evidence or identified any information that would suggest that at any time the surface area of the west-facing advertising sign display ever increased. I listened with great interest to the board's comments with regard to the structure itself and the number of structural members, and depending on the angle at which you observe the sign, could there have been some change or not? Again, we don't have any other information to offer with respect to if there was some modification to the structure itself. What we can say is what we have said consistently, which is that the west-facing advertising sign display has consistently been maintained at 20 by 60, 1,200 square feet. So to the extent that there would have been some modification to the underlying steel or some work done on a supporting steel structure, we submit that that should not result in a loss of non-conforming use status for the display of the advertising signage. Because if taken to its logical conclusion, you could then argue that if you just replaced a bolt or a screw somewhere along the way, this valuable property right would be lost forever. So the east-facing sign looks like it did increase at some point in time. The west-facing sign, we believe, has been consistently at 20 by 60. I think there's no dispute, and DOB conceded in its last submission that there were two signs on the roof of that building. Obviously, from the 1978 photos, there are two signs on that building in 1980. To the extent something on the east was changed, that's, it is what it is. I mean, we can't, I don't have anything else to offer with respect to that, but we would seek to have at least the west-facing side of the sign and the valuable rights associated with that sign structure confirmed. And to that extent, we believe that the decision of the Queensborough Commissioner, which is the subject of this appeal, should at least to that extent be reversed.
So my question, I'm sure the commissioners may have other questions. My question is on 4255A, or actually C. It says any advertising sign erected, structurally altered, relocated, or reconstructed prior to June 68. That's the first test, that you had to have established your size prior to 68 or 79, similar, right? But then you have then you have the same restriction in, sorry, I'm missing it, 52. Somebody want to jump in with a section?
5283, Madam Chair.
Yeah, 5283.
Sure.
So what you're arguing is, if I'm understanding correctly, if you have a really big structure, but your sign is, let's say, half the size of that structure, if you remove a piece of the structure that's not affecting the size of the sign, you're saying that 5283 isn't affected.
Well, 5283 would come into play if we were talking about an increase in the degree of nonconformity of the sign, or if we were increasing the surface area of the sign, or increasing the degree of illumination of the sign. There's a bit of an interplay between 5283, which is a statute of general applicability, and 4255, which is specifically applicable when you're talking about arterial highway signs. So here you do have to refer to 4255. 4255 makes reference to structural alterations and modifications. But again, our argument is that what you're not doing here is, if you're not showing an increase in the surface area of the sign, or the thing which makes the sign non-conforming. Again, we're all talking about non-conforming signs because there's restrictions on advertising signs located that proximate to the arterial highway. Changing a bolt or changing a supporting structure, let's say underneath or in back of the sign structure, does really nothing to take advantage of or try to change compliance with current law in terms of the display of advertising signs. It's not as if you were making a structural modification to, let's say, go from a 14 by 48 standard industry size sign to a 20 by 60 standard industry size sign. That this was consistently a 20 by 60 display, and the steel elements that supported it were in some way modified. And again, I'm not even conceding that they were, but even to the extent that there was some modification, because the 20 by 60 advertising display stayed in the same location, same positioning on the roof, we don't believe that that's the way 4255 should be read to foreclose this valuable non-conforming use status. We didn't make the sign bigger. We didn't change the degree of illumination of the sign, which are the things that I believe that the law was designed to guard against. Someone getting a permit for one sign and then making it bigger, or adding a second side when it's only for single phase, or adding illumination when it's non-illuminated, or changing the position or the angle so that's a better read. These are all the policy considerations that went into 4255, the predecessor 4253, and then blended with that the 5283 general principles on non-conforming uses. So we think that.
Okay, I'm sorry. Go ahead. Sorry.
No. So I think that was really my point, Madam Chair. That really we think that the non-conforming use really attaches to the way in which the sign is used, and we didn't change the 20 by 60 use for advertising sign on the signage on the roof of that building. You know, if there was a change, and I don't even know if there was a change. Again, I haven't seen anything which says that there was a particular change. But if there were a change, and let's say there was, one structural member was cut back, or the sign was, maybe trimmed to fit better the display, the advertising sign display, I don't think that work would constitute work that would result in a loss of non-conforming use status, or at least it's not what the policy behind the law was designed to guard against.
Thank you. I see hands up from all the commissioners. I just want to clarify the language in the text. So 5283, just to recite that, does not allow the creation of a new nonconformity or the increase in the degree of nonconformity. That's one. It also doesn't allow an increase in the surface area of the sign or an increase in illumination. So with respect to the west-facing sign, the appellant says there was no increase in those things. But 4255A says no advertising sign shall, an existing advertising sign shall not be structurally altered, relocated, or reconstructed. So one of the questions that's before us, it seems, is if the sign sustained its size on that west-facing sign, and then the structure underneath it were removed, which seems kind of crazy, but maybe, yeah, it starts to decay and maybe the structure is removed, but it's not affecting the actual surface area of the sign. Does it trigger 4255A2? When we look at 4255A-C, it talks about, the grandfathering of a sign less than 1,200 square feet. The grandparenting of it is as to its size, the surface area of the sign, not as to the structure. Unfortunately, the sign regulations don't adequately cover the subject of structure, which is often our problem when we're trying to review these materials. So Commissioner Ollie Brown had her hand up first, then Commissioner Shanda Sheta, I believe.
So when you look at the two photos, it's clear to me that something happened, because the relationship of the sign face to the structure is different from the 1978 photo and the later photo. It actually, the sign face totally covers the sign structure. So that leads me to conclude that one of two things happened. Either the sign got larger or the structure was altered. And so the question is, the possible altering of the structure, how does that get defined? And how is it defined in relationship to 4255A, which forbids the reconstruction of advertising signs within 200 feet of an arterial? So the question is, if you're removing that sign face so that you can significantly alter the structure, is that reconstruction of an advertising sign? Or is it only if you literally break apart the sign face itself and put it back together, that's reconstruction of the advertising sign? So that's my question.
And Commissioner, again, I don't think any other types of modifications or alterations to the supporting structure that don't have any impact on the surface area of the sign or the height above curve of the display area of the sign or the degree of illumination of the sign is what would be intended to cause a removal, to cause a loss of non-conforming use status. If for no other reason than there could be safety issues involved, you want to at least make sure that there is some reasonable opportunity. I lost you. That there's some opportunity for for regular and routine maintenance and safety checks of the structure. It can't be that the sign structure is basically left to sit in amber, not to be touched at all from 1979 to the present, because you can start getting down a slippery slope of, well, if can I change this but not that? If what we're doing is we're preserving in place the use which is non-conforming is for the display of off-site advertising. It's not even for the display of all manner of signs, because if those who are displaying a non-commercial copy or accessory business copy, you'd be talking about different restrictions and different limitations. So the use, what is non-conforming, what is governed by 4255, specifically with regard to this sign, is the advertising sign use, which is what attained non-conforming use status as of 79. We submit that 79 is the appropriate date because it's not disputed that both sides of the sign, neither one of them exceeds 1,200 square feet. So we think that that's the use. Yes, there could be, and again, I've represented the sign industry for 20 plus years, but I'm not an engineer. I can't say that there isn't, something different in the architecture of the steel that surrounds the sign or supports the sign. But the non-conforming use, which is what 4255 and 5283 are designed to regulate and to guard against illegal activity in connection with, I don't think we're violated by that type of other work, which could have been done for litany of purposes, including safety and structural integrity and general maintenance. But that's I think where we're at on that.
Okay, thank you. Commissioner Shanda? You're muted. You're muted.
Okay, sorry. I go back to the way one would measure the sign structure, and what I would like both DOT and the appellant to do this exercise, basically use a comparative measurement stick to measure the sign that was there in 1978 and use a comparative measurement from the 2018 photo and measure the size with that. Because what I mean by that, and that will clearly, to me, I just cannot get over the fact I'm using the bulkhead. The bulkhead has not changed from 78. And what I mean by the bulkhead is the roof, the staircase bulkhead that's on Borden Avenue. That has not changed. Just use that as a measuring stick. And if you measure the sign that's facing west in 1978, and then take this measurement of the bulkhead that from 2018 and use that measuring stick to the 2018, I had done this again as we were doing this hearing. It has changed. The sign structure has changed. It, in comparison to the roof, the stair bulkhead that's located at the corner of Borden Avenue, the sign has increased on the west facing side compared to the in 2018 compared to 1978. It's a very simple architectural trick that we all architecture students learn from day one. When you look at a photo, try to figure out what is actually the length of a building or something, use a standard and then repeat it several times and see comparatively. That's a very simple thing and it's very clear to me. And I think my question, therefore, is the structure itself. yes, I understand the structure. You would need to do repair and you would need to change certain elements of it. You may need to take it down and rebuild it in place. Exactly. You can reduce it. But I think that can easily be measured. You can, and the applications that's been provided so far has been consistent. If it was a 20 by 60 sign back in 78, as it is today, definitely from the measurements I did, it was not a 20 by 60 sign back in 1978. It was something less than 20 by 60.
I just want to throw in that when you're using a photograph to measure from, the difference in perspective affects the measurements. And when you
I understand that, and that's why you try to pick something that is closest within the same thing that will also progress, that will also change in the similar way, but it can't change in a way where it's dramatic. That's
right.
all.
So normally my experience is you count the bricks, because the bricks are all the same size. There's always 21 bricks going up, still 21 bricks kind of thing, as opposed to using the bulkhead. But in this case, we can't count the bricks because the drawings are too fuzzy. So I'm a little concerned about using perspective, but I do agree there needs to be some kind of measurement system introduced by both DOB and the appellant so that we can say, you know, this is measurement technique we're using, as opposed to, you know, count the sticks, because I can't see the sticks in the photographs. So so then Commissioner Shibeta was next.
Thank you, Chair. As I alluded to in my review with regard to permissible repair and maintenance of a structure, I believe that interpreting the language to mean any change in the structure would cause the loss of the non-conforming sign would be against public policy, as it would encourage owners to neglect the safety of their sign. And I don't think that's what this, I don't think that was the intention here. Now, if there was an increase in non-conformity, that would be a very different analysis. With regard to the perspective of these these photos, again, I don't have the mathematical formula in front of me, but I do know that we would need to know the precise angle and the location of the picture to determine whether or not to be able to do the math to see if the signs are different. I don't know if based on the data that we have in front of us, I don't believe that there's a way to do that. I implore the applicant and the DOB to provide more information, but at this point, I sincerely don't feel confident on making a judgment against an owner on this west-facing sign without having something a bit more concrete.
Okay, thank you, Commissioner Shibeta, and I see Commissioner Otley Brown's hand up again.
I just spoke. I'll have Commissioner Shedda speak.
Yeah, what a good idea. Sorry. Commissioner Shedda.
Thank you. Probably, if I recall correctly, this is the first time I disagree with Commissioner Shabat. The text in the zoning resolution regarding the structural alteration is not related, shouldn't be related to increasing illumination or even the size of the sign. It shouldn't. The way I understand this is the writers of the zoning resolution, after a specific date, they prohibited constructing these kind of advertising signs in close proximity of highways and parks. And the reason they put that text regarding the structural alterations and they prohibited that is they wanted to make sure that every sign that's existent at that time, after it deteriorates and becomes like salvage, it's not going to be renovated. It's not going to be that its lifetime, it's not going to be extended. So they wanted to reduce this kind of advertising signs but not in a shocking way, like remove them now. Whatever exists, let's leave it there. And little by little, it's gonna structurally deteriorate. And then there is no other path to renovate or strengthen these kind of advertising signs that we hate them from the structural perspective. So this is the way I believe, in my opinion, this text should be looked at. The second point I want to talk about is the changes in the two signs, east and west. Each sign, am I convinced that it was changed? It was, the service area was increased? One word? No, it was. I can see this on the picture. It's very evident, it's very crystal clear for the east facing side. For the west one, although I was like at the beginning, like skeptical, but I have done like an exercise that I counted. I'm an engineer, I design trusses, and the kind of structure that these two signs are supported on is called the space truss. Number one, you cannot dismantle a space truss, otherwise it's gonna be tumbling down. So you cannot come and cut a member that's governing the stability of that structure. It's kind of like extremely tough to do it. But I counted the members that spans the base in the structure to the left, in the, for the, I'm talking about the west facing sign now. That photo that's from the DOT like records. And I counted the base, and then I went to the other sign, to the same sign, to the other picture from 2018, and I counted the base too, from the same exact pictures that were submitted by the DOB. For me as an engineer, the one to the left, the one with the, that says bucking, or that old one, it's very straightforward. You can see the heavy dots. These heavy dots, these are the gust plates, the plates that the members of the truss are welded to. And these are like the milestones for the base. These are the end points for the spans of each bay. So I counted on the 1978, I counted to 7. So we have 7 spans on the left side. If you count to the right, on the same pictures, I took a copy to the paintbrush, a drawing software, and I put vertical lines. I can share a screen with you actually. I'm not sure if you see this.
Yes, we see.
Okay, if you look at the left, you can count 1, 2, 3, 4, 5, 6, 7 spans. At each like dark point, this is, like I said, this is the gust plate. And you see 7 spans for the space truss. And the span number 7 is holding nothing. It's not holding any sign on top of that. But if you go to the other one, I was able to count 8 spans. And I was like tough on myself, like many other engineers. No, this is not right. You didn't count it right. So I actually tested myself. So I went to the Google Maps and I did like a snapshot from the Google Maps. And let me try to share the other one. Which was this. Same count. I got the same, if you count 1, 2, 3, 4, 5, 6, 7, 8. So we got 8 spans. And if you look at where I'm pointing right now, you see this member, this member, this member. These are like the end points again of the base of the truss. So this is space truss that's currently in place, has 8 spans in place. The other one, very clear that it wasn't 8. it was 7. This is in addition to that. If you look at the 2 signs, one of them is spanning partially to the right-hand side end of the structure. The other one is spanning the full length of the structure. So for me, I have no doubt that the structure, either the structural was altered or the sign was increased, or actually, and I'm tending to the third one, both.
Okay, thank you very much. Super helpful.
Thank you.
Super helpful. Wow. Okay. All right. Let me just see if there were any, and Commissioner Otley Brown had her hand up. Go ahead.
I just wanted to say in response to the vice chair that both of those photos were taken from slightly different position, which would make it very difficult to make that kind of a direct comparison.
Mhm.
So I'm not sure that I agree with her position on this, but to me, what makes me hesitate is the aspect ratio of the sign on the left, regardless of the structure, looks very similar to the sign on the right. It doesn't look like the shape of it has changed much in when talking about the height in relationship to the width of the sign. And so that's why I'm hesitant to say that the sign is gotten larger.
Okay, thank you. So what this all comes down to, and I think Commissioner Sheta's analysis adds more layer to this, but what it comes down to is both appellant and DOB giving us a clearer measurement methodology so that we could feel, those of us who are not sure could feel more confident in one way or the other. Okay, thank you. Okay, so now having gone through all of that, DOB, please.
Good morning, Chair and Commissioners. One thing, and as just a reminder, and I don't know, do I have a screen sharing capability?
I think so.
Seems like it. Okay. So I just want to note that with my original submission, I included Exhibit A and G, which were numerous more detailed photos of both Google Maps and particularly the New York State DOT photos. And then I took excerpts or smaller cutouts of those and put them actually in the body of the submission. So to the extent there's a problem with the clarity of the photos in the actual submission, either my first or my second, it might help to take a look at those photos. I want to note one thing, which is the department's position is that pursuant to Rule 4915B, the burden is on the applicant. So it's the department here who went and requested the New York State DOT photos. I'm caught a little bit off guard because at our previous hearing, I thought that commissioners were in agreement that the west-facing sign was also expanded. So, I didn't ask any of DOB's engineers. I didn't do any calculations because I did not realize this was an outstanding issue. But I do want to note, pursuant to the rule, and I can read here, this is 49B15B. It states the evidence submitted must specifically establish the non-conforming aspect of the sign, meaning the applicant, and that's specifically with respect to non-conforming signs, meaning the applicant must prove that the size of the sign now is the same as the size of the sign when it became non-conforming. So I believe it's the applicant's burden to prove this, and I don't think the applicant has done that. So I just wanted to make sure to note that. I wanted to note then two more things, or maybe a few more, but with respect to 4255C, I do just want to note that the signs have non-conforming use status to the extent of their size on the relevant date, which as Mr. Kilduff notes here is November 1st, 1979. And signs that are not in compliance do not conform to that size shall terminate. So it's the department's position that both the east facing and the west facing signs must terminate because their surface area increased. With respect to repair, I do want to note that ZR 5221 allows non-conforming signs to be repaired. So to the extent there's a safety issue, the prohibition on structural alterations does not prohibit repairs. So I don't think that's, there's no public policy concern here with respect to allowing structural alterations. If a part was in danger of failing or something of that nature, an owner would be allowed to make those repairs to keep it safe. And then finally, I think I'm going to try to share my screen here because I understand that the photos that I submitted in their small size with my statement might be not as clear as could be. But I do want to, I'm going to try to share my screen to take a closer look at the New York State DOT photos. Can you confirm that you can see the Allegheny?
Yes, we can see.
Yes, I can see it.
So I don't know that I'll be able to say it any better than Commissioner Sheda did with counting. You know, he did an analysis that that was more technical and sophisticated than I'm going to do here. But I just want to point out, if you look at this sign, you look at the right side of the structure, and then you look at the bulkhead on the right. I think you know it's clear that the sign does not go all the way to the edge of the structure. And then if we switch back to this photo, again, I acknowledge that the perspectives are different. You know, I did the best that I could with the publicly available information that I had. But I think what's clear is that the sign today goes all the way to the right side of the structure. And whether that's because the structure was modified, which is unlawful, or because the surface area increased, either way, that alteration was unlawful. And I believe that these two photos make clear. I don't have measurements. I think there could be difficulty based on the perspective and other things like that, providing specific measurements. But I think when you look at the structures, in the department's opinion, it's clear that the surface area of the signs increased, and therefore the sign must terminate. And just one final point, and I'm happy to answer questions. You know, I was prepared in October, pre the pandemic, to present this with the projector in front of the board, and Mr. Kilduff asked for adjournments. And now here we are, you know, 10 months later, not entirely due to the adjournment request of Mr. Kilduff. But he submitted new information. He submitted no information during that time. And here we are debating things 10 months later that I could have presented and explained to you in October. And so I guess I just want to note the department does have it. Just note the department's frustration that we've managed to, Mr. Kilduff has managed to delay this process while providing no new information.
Well, maybe, okay. It's true that we were hoping there would be more photographs or something submitted by appellant's counsel. Unfortunately, we often have that experience where on these cases where DOB has access to all of these sources, but appellant doesn't search for the same sources. It seems to me that the difficulty I'm having personally with the size of the sign is the first part of it is I don't really see either that the sign itself is larger. I see structure underneath the 78 sign that's not being used, but I don't understand, and I don't read necessarily the resolution as preventing you from removing pieces of structure. If, for instance, it was decided that they would never get away with using it, and so they decided to take it down. And I understand what Commissioner Sheta said, that it's hard to remove the end of the structure, but is it something they might do? And whether or not that triggers a structural alteration, I don't know, but I think that we need more on that. And I think Mr. Kildoff sees that you've got a board with a variety of views on this, some of whom are completely persuaded that the sign changed inside, and others of whom need to be persuaded. So in the interest of your client's property right, I would say you need to do more serious research and analysis to help those who are on the fence get to your side of the fence. Otherwise, not sure where they're going to go, right? So that's, does anybody else want to add anything? Any commissioners? Okay, any last comments from DOB or the appellant?
Just very briefly, Madam Chair, just to make it clear to you and to everyone on the board, we take this very seriously, and we recognize that this is a significant property right on behalf of not only the owner of the building, but also the outdoor advertising company that has the contract to operate the signage there at the premises. These are complicated issues with long histories. This is not something which is necessarily readily discernible all the time. We do use a number of different resources to do our research of non-conforming use status, but we're mindful of all the board's comments, and we're going to do everything we can to try to convince those that are on the fence or give them the documentation or the evidence that they need to support continued non-conforming use status, at least with respect to the west-facing side.
Okay, thank you. I would also ask if DOB and Mr. McKernan could provide us with some either BSA case or court case that talks a little bit about the meaning of, in case there's been cases, the meaning of structural alteration, the exact structural alteration, relocation we know, or reconstruction, because for argument's sake, since we don't know that they didn't just remove a piece.
Yeah, I don't think, just to be clear, the department's position here is not and has never been that they removed the piece. The argument is that the sign now currently spans the entire width of the structure, and I forget Commissioner Sheta's technical term, but we counted vertical supports, and by our count, it expanded. So
What expanded? Sorry, the sign or the structure expanded?
I think I articulated this in my first submission, but the surface area of the sign expanded in proportion to the vertical structures of the structure. So our position is that the structure is likely the same. The structure itself is likely the same size, but the surface area of the sign increased. So I just want to make that clear.
Okay.
And I believe that the term that Commissioner Sheta had used, I believe in the executive session, so that I'm clear, was it the rectangularity ratio? Because that's obviously what I want to.
Yes.
It is the same as the aspect ratio. It's actually, if you have a rectangle and you take the length divided by the width, that gives you the rectangularity or the aspect ratio of that rectangle.
Okay, just so when we're speaking with our engineers, we'll use the terms aspect ratio and rectangularity ratio.
Mm-hmm.
Yes.
In terms of case law, if you could also address the case City of New York versus Seal, that's SEEL from 1959. It was an appellate division decision that had to do with an interpretation about reconstruction.
Again, I'm just trying to say that was City versus Seal, SEEL?
SEEL, and it's 8 AD 2D 964.
Back when things were still printed in books.
Yay.
Yes.
And that's specifically sign related or generally?
It's specifically about signs next to highways and reconstruction.
Okay, great. Thank you. What year is that from? Just curiosity.
1959. So the prohibition has been around since about 1940, or since 1940.
Okay, great. Thank you very much. Okay. Any last minute anythings? We should see if there's anybody who wants to participate in this, even though it's an appeal. Okay. Yeah, go ahead.
I have a question, and this is for DOB. Maybe I didn't understand it. I thought the DOB stated that they do not question that the structure changed, the west structure changed. It's just that the surface area of the sign changed.
Yes.
Well, yeah. Sorry,
So,
you want to follow up?
right. If you're making that statement, then that is kind of contradicting what you just stated when you gave the demonstration of how the sign structure had moved, because now it's closer, or had widened because now it was closer to the bulkhead or the roof line, something like that.
You're confusing the surface area of the sign with the supporting structure.
I know, no, that's why I said what I wanted to be clear about is, did Mr. McCrennan say that the surface area of the sign changed, but not the size of the structure?
The supporting structure.
Supporting structure.
Right. That's our, again, I want to stress that DOB's position is it's applicant's burden to prove both of these things, but DOB's theory is that the structure appears approximately the same as it did in 1978. But at that time, the surface area of the sign was not equal to the full width of the structure. And now the surface area of the sign is equal to the full width of the structure. And so therefore that's a prohibited increase in surface area pursuant to 4255C, and therefore the entire sign must terminate.
Okay, so I understood it correctly. So going back to when you did the screen share,
sure.
You basically said using the screen share, maybe I misunderstood, is that the structure was now had extended because it was now touching one of the bulkhead along the Van Dam.
So I'm happy to screen share again to clarify, but
is that okay, Madam Chair?
Sure. Yeah.
Okay. Thank you.
So I think if you see where my mouse is,
yes.
I think roughly the structure goes to the bulkhead, the same. Did I lose?
That's not a bulkhead. That's that's like a roof in the distance, no?
Yeah, right here.
Okay, so I thought Vice Chair Chanda was calling it the bulkhead. Maybe she was calling the thing on the left side a bulkhead. But
no, I am talking about the right-hand side where your mouse is.
That's not a bulkhead. That's a structure on another building, I think.
So
right.
Okay, so I guess to me it's not key to put a name to what it is, but I think I searched it. I really tried to be careful in using the photos that I selected for the excerpts of my in my actual statement, which is to get as close to identical perspective when comparing the 1978 photos and the current photos. It's not perfect, obviously. Then Google, I don't know what technology they use today. It might have a bit of a fisheye. In 1978, the highway was different. I don't know what lane the truck was in, but they were taking photos from the top. So I really did my best to get an identical perspective to use both, the all the features of the building lined up as close as possible. But just to answer the question again, no, DOB believes that the structure is approximately the same width, but it's the surface area that has increased in width to match the width of the structure. And I believe we will be able to perhaps blow those photos up to count the members more carefully for our next submission.
Okay, thank you very much.
Okay. And in terms of the burden of proof, I think the burden of proof is very different when you come to the Board of Standards and Appeals, where the risk is loss of a property right. The burden of proof is actually, I'm not sure about this, but it could arguably switch to government because you're about to deprive a property owner of its rights, right? Maybe not a deprivation, maybe it's a right, but nonetheless. So I think that whenever we have the opposing sides, we're looking for as much proof from both sides. We're actually supposed to err on the side of the property owner according to lots of case law, right? When a situation is ambiguous and so on like that, right?
Well, I'll address that in my next submission. I do want to note 28502.4.3 states that DOB may require copies of proof that the sign complies with the zoning resolution. So that's by statute. DOB can require proof that a sign complies with the zoning resolution when submitting a sign inventory. But I'll brief specifically this issue in the next submission.
But that's the standard that applies to DOB. I'm talking about the standard that applies to the BSA because, of course, our decisions are in court. So we're governed by case law, right? Not the statutes necessarily. We're other than the zoning resolution and trying to interpret the text. Okay. All right. Thank you, everybody. So we didn't get any speakers yet. Let's see if we have any speakers. Go ahead, Kurt.
Calendar number is 2018-178, 5103 Van Dam Street, Queens.
Yes, and please call in to 646-558-8656 with the meeting ID 941-1217-8179. And again, the calendar number is 2018-170A. This is an interpretive appeal. And if you call in with your telephone, please raise your hand by pressing *9, although this is the last case, so we will presume that you would like to speak about this application.
So another 15 seconds. How much time then does appellant need to respond? And an appreciation of Department of Buildings feeling like it's being led along. We don't want to drag this out a long time. So I would say, what do we have to do here? So how about an end of October continuation? Something like that, or early November. Does that work?
That would work.
Okay, so we'll handle and so the briefing schedule will be accordingly. But if you find any last minute proof, feel free to submit because that's what we're relying on, right? I mean, I would have to say if you found something that proved definitively that the sign had not changed in size, or proved definitively that the sign had changed in size, that a submission kind of at the last minute would be appropriate in this case. Just only fair, I think. Are people okay with that? Okay. All right then. So nobody called. Okay, good. Thank you everyone for your participation.
This concludes, we're finished? This concludes the public hearing for our August 10th, 2 p.m. session.
Okay. Thank you, everyone. See you tomorrow.
Bye.
Bye.